Greetings and welcome to the Women in Fire radio show. Today we will have the discussion on firehouse law, mapping the minefields. Thank you for Fire Engineering for allowing Women in Fire to be part of your radio show. I'm the Southwest trustee, Lisa Baker, and today I have co-hosting with me Kat Desonier, who is a firefighter from Evans Fire in Colorado. Our host is, I'm going to allow our guest speaker today, who's going to be discussing the topic, to go ahead and introduce himself and give a brief bio of himself. John?
My name's John Rukavina, and I thought I was on track to be a lawyer, but I was seduced by the fire service. So I finished my law degree and then went to work and eventually became a fire chief in Missouri and then in North Carolina and then public safety director in Wake County, which is where Raleigh, North Carolina is. And during that time, I kept up my contact with the law. And all I can say is, as far as the law and the fire service goes, is we're living in very interesting times. And that's what I'm going to talk about, kind of current legal issues. And there are more surprises in store this year, so stay tuned.
So let's go ahead and get started. So let's begin at the beginning. What is an executive order? We keep hearing a lot of things about the president's signing executive orders.
An executive order is theoretically an order directed at the executive branch offices, departments, and that's basically it. It's not a law. Doesn't have any direct impact on states, state laws. Federal rules and regulations are adopted and changed under the law the way they always have been. So, for example, Equal Employment Opportunities Commission is a little short of members right now. And if it doesn't have enough members, then it can't change or amend rules they've already issued or guidance they've already issued, although they can hide it, which they've done in a couple of cases, and I'll talk about those.
Okay.
But it's a very strange animal, and we're finding out through, I think, over 50 lawsuits now, where the authority of executive orders begins and ends.
So are the lawsuits from different agencies, different states, different departments within the government?
All of the above.
Okay.
In the case of government employees who have been laid off or terminated, quite often those employees individually or in groups are suing. States are suing. I don't think governmental departments are suing because I think the president has his departments, his secretaries installed, and there's a program that they're sticking to. So I don't see anything changing from that end, although a few brave souls in the upper echelons of federal government departments have stepped forward and pointed out issues that have arisen. So right now we're very much up in the air, and I'm really interested in making sure that fire departments and municipalities don't take any hasty action based merely on the presence of an executive order. It does have some impacts on fire, and we'll talk about those. But generally speaking, your department is governed by state law and local ordinance, and not generally by federal law, although to the extent that it is, and you work with executive departments in the government, then those executive orders can have an impact.
Thank you.
Does an executive order override state laws or regulations?
The short answer is nope. But again, the president and the executive offices are moving forward on the assumption that somehow they do, and that's why there's so much litigation, so many stop orders isn't the right word, injunctions against carrying out executive orders as far as they apply anywhere outside the federal government.
So if an executive order is not a law, then how does it affect the fire departments?
Well, a number of fire departments have interactions with the federal government, and I'll give you an example. Fire departments that have Fire Act grants become subject to a very limited extent to those executive orders because it is possible for FEMA. First of all, FEMA paused all the grants, and the fire departments couldn't do anything about that. That was FEMA responding to an order from its boss, the president. And the second thing is FEMA was also reviewing all of those Fire Act grants, presumably to see if there was any unauthorized or activity going on or being financed by those grants that was inconsistent with other presidential executive orders, the principal one being DEI. And speaking as a lawyer, I'm troubled by the DEI issues because nobody can give me a short, succinct definition of what DEI is. It seems to be in the eye of the beholder. But in any event, I believe that's the reason why FEMA was and the U.S. Fire Administration were reviewing all of the outstanding grants. And I'm sure that when grants are sought in the future, the grant applications will have to toe the line as far as executive orders go. So that's the principal way it affects fire departments. The indirect way that it affects fire departments now is that there is a lot of useful information that comes out of federal departments like the Department of Labor or the Department of Justice, believe it or not. But the principal agency that the fire department relies on, or the two agencies, are the Department of Labor and the Equal Employment Opportunities Commission. So EEOC put together a really interesting workplace guidance bulletin on preventing harassment in the workplace. But if you try to look it up on the internet, what you'll find is the requested page could not be found. So a number of these resources have been taken down. Now, the good news is that if you look up EEOC releases workplace guidance to prevent harassment, fortunately, you'll find a number of very good newsletters from law firms and other agencies that essentially lay out and explain what that EEOC guidance said. So it's on the strange side. The second one is a bulletin again from EEOC called Moving Toward Equality in the Workplace for LGBTQI plus employees. And if you look for that on the internet, you'll see a little indication that says the page that you're looking for cannot be found. And again, that one is just an informational bulletin, not official guidance or rule. So presumably no special authority was required to take it down. But I think everybody who's been following what's been going on in the context of DEI knows that LGBTQ is a touchy issue right now in the federal government. So that resource, again, is not available online. But if you look for equality in the workplace for LGBTQ plus employees, again, you will find those articles and those explanations of that bulletin without being able to get to the bulletin itself. Now, there's a very, very important document that was issued by EEOC about 1 year ago, almost exactly 1 year ago. And it was the implementation of the Pregnant Workers Fairness Act rules and guidance. And early on in January and early February, there was a lot of conversation that was going to be, that guidance or that rule actually was going to be withdrawn. And one of the reasons for that is that 19 states sued, I think, in the Eighth Circuit Court of Appeals, saying that because the EEOC rules say that abortion or stillbirths or anything like that is covered by the Pregnant Workers Fairness Act because it involves pregnancy, that those rules were going to be withdrawn. But all the Eighth Circuit Court of Appeals in that case said was, Attorneys General, you can go forward with your case. We're not going to stop you, but we're not ruling on the merits of the case. You still have to go to lower courts and go all the way up through the usual chain. So on February 23rd, there was an announcement that EEOC is not going to move to withdraw those rules. So they're still in effect, they're still in place. If you're implementing the Pregnant Workers Fairness Act in your department, that is a very important set of rules to have on hand. So we have some really amazing stuff.
So I got a little follow-up. So you said FEMA, and then so the USAR teams aren't they're under the umbrella of FEMA. So how is this going to affect possibly USAR teams?
I think that I haven't seen anything emerge on that. The most likely way it could be effective is if there is any kind of contract that exists between a participating fire department and FEMA with regard to that, that they may see when the contract comes up for renewal, a contract with some slightly different provisions in it.
Okay.
So, and I think that what will probably happen if that does occur is once again, somebody will file for injunctive relief to have those contract changes essentially pushed out. One argument would be that they have nothing to do with the subject matter of the agreement. But I guess the recurring theme, at least in the first half of this year, or in this first year of President Trump's administration, is time will tell.
Do you have any advice for fire chiefs on how to proceed in this environment that we're in with all this going on?
First of all, be very familiar with your state laws and what they say, because those are your primary guidelines. Normally, the federal government exercises no jurisdiction over local government fire departments. Again, you have that indirect control, and through the Fire Act grant process, fire chiefs have to be aware of that. As far as any other particular steps to take, I would stay very tuned in to your fire service periodicals and publications, to the organizations that you belong to, and to a good daily newspaper to keep track of what's going on. But generally speaking, the effects on the fire service are indirect, and there really shouldn't be many. There are some other effects, and we'll talk about those. I guess we might as well talk about them now. The Department of Justice has intervened with local police and fire departments in cases where some severe issues regarding harassment or workplace misbehavior. And usually what happens is the Department of Justice files to intervene in those cases. Most recently, this happened in the city of Minneapolis, my old home territory. And essentially, the Department of Justice serves as kind of an overseer and developing a plan for a police department or fire department to deal with that. And we've had two of those within the last couple of years in the fire service. One is Cobb County, Georgia, and the Department of Justice intervened for two reasons. One, the county of Cobb was including credit reference checks as part of the application process, and that's against federal law. And the second is there was some substantial evidence that the entry-level testing that was being used was really not job related. So in the midst of that, the Department of Justice was involved, and they were working on the final product, and then they decided to withdraw. And they withdrew because Pam Bondi, the Attorney General, has announced that the Department of Justice will no longer be involved in harassment or inappropriate behavior on the part of police or fire departments in their intervention policies. So the Cobb County case is now gone. And then in Kansas City, Missouri, there was a discrimination investigation. And this was, if my memory serves, this was in connection with sexual harassment generally and harassment of gay firefighters, one or more gay firefighters in particular. And again, the U.S. Department of Justice has ended its investigation into discriminatory employment practices in the Kansas City Fire Department. So Kansas City will have to make its own way. And the latest headline was early in February, Attorney General Pam Bondi dismisses DEI lawsuits involving police officers and firefighters and advances President Trump's mandate to end illegal DEI policies. So their withdrawal from the field of battle, as it were, is again based on DEI. I guess one more, and I haven't seen any more on this. And that is an EPA official in the environmental, excuse me, can you pause?
So I got a quick question that kind of goes back to the other question. So
Yeah,
the National Fires or the Fire Service and federal firefighting, the federal firefighters, how does these executive orders affect their departments, if at all?
they affect them very directly. As a matter of fact, I'm looking for the information here. Um, there is a women wildland firefighter program, and that was canceled. Matter of fact, it was canceled very early in the process. And most of the people I talk to are of the opinion that DOGE is using AI to just search federal programs or federal activities, and that women might be one of the key words they're looking for because the Forestry Service was directed to cancel that program. And I think everybody knows by now what happened with the Women in Fire weekend at the National Fire Academy. What strikes me is that that was one of the earliest victims, if you will, of the executive orders. That happened fairly early, significantly before all of the resident programs at the National Fire Academy were postponed. So it's the most interesting thing, the most tragic thing in my view, is that last fall, the Department of Labor announced that it was going to identify, I think, 3 or 4 cancers as presumptively job related for women federal employee firefighters for retirement or disability purposes. And if you look for information on that now, it doesn't exist. And if you call the US Department of Labor, they don't know anything about it. And I don't have the document in front of me that has the particular cancers, but I know for sure uterine cancer was one. And so it just, it seems like a number of these things have just vaporized. Now, something that's health and safety related as far as firefighter generally are concerned is that EPA has announced that it is going to not proceed further on stricter rules on PFAS. So apparently the federal government and the Environmental Protection Agency in particular have done as much as they're going to do with that for now.
Okay. So let's go on a little bit different direction here. So what's the latest on marijuana? Is a positive THC test enough to get a firefighter fired?
It depends on where you live, but my advice is if your state has authorized the use of medical marijuana, marijuana for medical treatment purposes, then the odds are very good that a positive THC test by itself is not enough, is not sufficient grounds to get a firefighter fired. What's happening in more and more states is that a THC measurement, first of all, nobody agrees on what quote unquote intoxication is for THC. It's a function of how often you use marijuana and what the time period is. But scientists seem to agree that the peak level of THC in your bloodstream is usually 10 to 30 minutes after you finish using marijuana. So that fact that that would have any impact in the workplace is very unlikely. So what people are looking for now is evidence of impairment, not just a positive THC test, but evidence of impairment. Now, what makes this a little interesting is that states are free to decriminalize the use of marijuana, to make it legal for medicinal purposes, but federal law says that marijuana is a class 1 drug, and therefore it's unacceptable. And if your fire department requires fire apparatus operators to have a commercial driver's license, then they're under those federal standards, and they may not necessarily be fired, but they could lose their CDL if they test positive for marijuana, whether or not there's any evidence of impairment. So that's the big thing. Once again, as I said in the case of the presidential executive orders, check your state laws. Check your state laws for a provision that puts firefighters and police officers and paramedics in a separate category. Those are, in many states, they're considered safety sensitive positions. So they have rules that apply to them that may not apply to, say, somebody who works in a manufacturing plant. It helps to remember that there are three basic rules as far as drugs in the workplace go. One I just talked about, and that is as far as marijuana is concerned, if it's federally regulated, then there's no slack. As a matter of fact, if you are recovering from an injury and you are on medical marijuana, then the federal Americans with Disabilities Act doesn't cover you because, again, marijuana is considered a class one drug. There is a move underway currently in the Drug Enforcement Administration to have marijuana reclassified from class one to class three, which is the same class that steroids, for example, are in. If that still happens, it's expected to happen a little later this year. The second thing is, notwithstanding a state's approval of medical marijuana or recreational marijuana use, an employer, namely a fire department, still has absolute authority in all 50 states to ban the possession or use of marijuana in a fire station or at a fire station. So even if you're on medical marijuana, if you're going to smoke medical marijuana, my advice is don't do it on fire department premises. I think a couple of firefighters have already tried to test that and they've lost. Lisa, one of the things I said I'd send you was my PowerPoint presentation from
Yes.
FDIC and Women in Fire. And I've got a great web link there for a website that goes over all the laws in all 50 of the states. So if a fire chief or firefighter wants to have a quick look at what the provisions of those laws are, I'll be sending that to you, and then anybody who is interested can contact you and get that information.
Yeah, and at the conclusion, I'll go ahead and give my email address. I got a question though. In some states, marijuana is legal. So
Yeah.
how does that affect not just medically marijuana, but legal?
Yeah, that's recreational marijuana.
Yeah.
Then the question in those states, I think you can bet on the fact that since recreational marijuana is legal, B, there is no scientifically accepted minimum level of THC in the bloodstream that defines marijuana or THC intoxication. And C, THC concentration over time diminishes absolutely almost in a vertical line after 10 or 15 minutes. And D, although there are two states that are working with a marijuana detection device that uses saliva, it doesn't detect a level, it simply establishes a legal basis for a blood test or a more formal test. So what people are saying now is the standard you need to go by, especially in those states where recreational marijuana is legal, is the person impaired? And fortunately, there is a mechanism for determining that. Hang on, I've got my notes here and I want to get the title of it right. There is training that's available for law enforcement officers that's sponsored by the American Association of District Attorneys and the International Association of Chiefs of Police, that is designed to train police officers in identifying impairment in the cases of both alcohol and drugs. And my advice to fire chiefs is to find out if there is a cadre of police officers in their jurisdiction that has that training. And if so, then to make arrangements that if there is a firefighter that somebody suspects is intoxicated by whatever material, marijuana, other kinds of drugs, that they take advantage of the training these people have. I've had several chiefs ask me if firefighters can undertake the training. The answer is, I don't know, but I would not recommend trying to do that kind of assessment with your own personnel in your own department. The second trend that's evolved is that because of the complexity of all of the issues regarding drugs and drug relatedness and partial and full drug legalization, that fire departments consider retaining a medical review officer to supervise the department's drug regulation program. Because that area has become so technical now. I know that a lot of police departments are doing that, and again, for the same reason, because of the complexity. And that medical review officer can kind of take control of suspected drug use in your department and move it through the process and do it in a way that will withstand legal scrutiny if it becomes important. But again, the bottom line is more and more states are looking not at how a blood test turns out, but whether or not somebody is actually impaired by drug use.
So it
One other
sounds
thing I'd like to mention, there are a lot of different products out there that contain tetrahydrocannabinol or other marijuana metabolites. And my warning to fire chiefs to share with their firefighters is that almost every label on marijuana gummies or anything else probably misrepresents the amount of THC or other marijuana metabolites in it. The best example now is vape weed. Most vape weeds now will test high enough that if your department is relying on a blood test, you will definitely test positive for THC. So it's really hard to find anything that has a low enough level of marijuana metabolites, THC in particular, that is accurately and scientifically verified. So use THC gummies or marijuana gummies at your own risk.
So it sounds like there's no way to necessarily breathalyze test. There's blood tests, and like you said, they're coming up with saliva tests. What are your recommendations since that's not there?
Well, I think I've talked about those, and I guess I got ahead of the questions. But A, find out if you have access, whether it's through state patrol or your own local police department, to those police officers trained in identifying alcohol or drug impairment. Number two, make sure that that information is shared with your folks, that if you're going to deal with this, it needs to be widely known in the department. And number three, think very carefully about getting a medical review officer to help you out. Again, because the area is getting so technical. And number four, do not hold your breath waiting for a breathalyzer for marijuana, because again, the reason there's no breathalyzer test is because there's no medical standard to judge when somebody's intoxicated. The only way to judge is by performance, namely performance ability under the circumstances.
Okay. So are there any other trends that we should know about? You talked about, I mean, how cities and or states are working, and some police departments have to work with their department to try to have a testing process. But there's any other trends? Like I know some departments have random drug testing and such. So
And random drug testing is subject to those same shortcomings in states where you have medical marijuana. Even if it's random, it doesn't change the fact that there's no medically accepted intoxication level for THC in the bloodstream.
okay.
So random drug testing is fine. It might be an indicator that you want to test somebody's impairment, and it may turn out, as a matter of fact, I think the odds are better than even that it'll turn out that there's no impairment, because again, marijuana takes a significant amount of time to, or I shouldn't say that, THC takes a significant amount of time to get out of the bloodstream, generally week to 10 days. And if you're a regular marijuana user, up to 30 days, you'll have THC in your bloodstream. So THC alone is not an indicator that you're impaired. Now, that's not true in all states. There are states where you can fire a firefighter for positive THC and you won't risk any legal blowback. I don't recommend that approach because I think that eventually in all 50 states, the test will be impairment. But be guided by your own state laws and what they say.
Moving on from that topic, let's talk about what excited delirium is.
Well, I think everybody probably heard about the two paramedics in Aurora, Colorado, who were called to an incident with three police officers involving a gentleman named Elijah McLean, who was going through what people now call a behavioral medical emergency. But a lot of cases, including one of my medical directors in a department I worked in, called it excited delirium, and they actually believed that was a medical condition. And we'll talk about the strength of that belief momentarily. So when Chikuniak and Cooper, the two paramedics, arrived, McLean was face down, handcuffed, had vomited, and was having difficulty breathing. He went into cardiac arrest in the ambulance and died 3 days later. At the incident scene, one of the police officers asked the paramedics to administer something to calm him down. And one of the paramedics, Chikuniak, administered, God, I have to look at my notes here. Ketamine. And there's a lot of argument about how ketamine is or isn't effective in the context of a behavioral medical emergency, because ketamine use, as I'm familiar with it, started with pets that I own. Ketamine is a commonly used anesthetic or painkiller for pets if you take them to the vet. But in this case, Elijah McLean was administered an overdose of ketamine, and the paramedic admitted that that was the case. He misjudged the dosage, and he gave him, I'm checking on this, 500 milligrams above the safe limit. And he and his partner paramedic were tried, found guilty, and Chikuniak was sentenced to jail time, and his partner was sentenced to probation. Chikuniak got 3 years in prison. Eventually, those sentences were reviewed and they were released after having served time. But we've been living with this diagnosis of excited delirium for about 40 years. And physicians have taught paramedics that it explains how someone experiencing severe agitation can suddenly die while being restrained. There is no blood or other diagnostic test that can confirm excited delirium. And the problem is excited delirium doesn't exist. The American College of Emergency Physicians adopted it as a diagnosis after a paper was published. But when the paper was examined more closely, the American Psychiatric Association withdrew recognition of excited delirium in 2020, AMA in 2021, and the National Association of Medical Examiners in 2023. And finally, in March of 2024, ACEP withdrew the paper, and the excited delirium diagnosis no longer exists. So, what do fire service leaders, what do they need to do? First of all, they can familiarize themselves and their firefighters with some really nice video resources that come from the Associated Press and let me see, there's one other agency. And Frontline have both created videos on what's called a lethal restraint. And essentially, they talk at length about the phenomenon of behavioral emergencies and police and fire interaction. So if you want to familiarize your folks with behavioral emergencies, that's one way to do it. Number two, check with other fire departments to see what they've done. Long Beach, California, put together an integrated medical response plan for dealing with behavioral emergencies. And in the materials that I'll send you, I've got a link, Lisa, to a copy of that document. But the most significant document, and this has got to hold the world's record for the longest title of a document, Consensus Statement of the National Association of EMS Physicians, International Association of Fire Chiefs, and the International Association of Chiefs of Police, Best Practices for Collaboration between Law Enforcement and Emergency Medical Services during Acute Behavioral Emergencies. What more can I say? That is available. Again, I've got a link to that so you can get a copy of that document. One other piece of advice that I've heard with fire departments and paramedics that have dealt with behavioral emergencies is that if you're asked to respond to a behavioral emergency, then a supervisor should respond, either a paramedic supervisor. If you're sending an engine company with firefighters on board, then my advice would be to send a chief officer along with those firefighters. And I think that person's role should be to observe and act as a referee, because I think the one thing you can be pretty sure of is not many police officers are paramedic certified. And you need to keep in mind that not many paramedics know enough about law enforcement to know when they're perhaps getting an inappropriate directive or order from a police officer on the scene. So I think that long title document from the EMS Physicians, International Association of Chiefs of Police, and IAFC would be a very important resource for fire chiefs to get familiar with and to use as a training mechanism for their firefighters. And in addition, because it has such a long title, I created a QR code for it. So Lisa, when you get that information, the QR code is there if you want to just point your camera at it.
Okay, cool.
And if anybody thinks that just because all of those medical organizations have said that it's dead, in January of this year, a Sioux City, Iowa rescue paramedic is facing an involuntary manslaughter charge for a 2023 death of a patient. And again, the case there, the allegation is that patient was given the wrong medication. This time it did not involve ketamine. But again, this is something where the information might be out there, but it's still a risk for firefighters and paramedics.
Okay, so changing the subject a little bit. Can an involuntary transfer be harassment or retaliation under Title VII of the Civil Rights Act?
The answer to that is yes. And that has changed just within the last year and a half. In July of 2023, the Eighth Circuit Court of Appeals, which is in the upper Midwest, said that a complaining employee separated from an alleged harasser by transferring the employee to a comparable position was not an adverse action. It was not retaliation because it was a comparable position. But in 2024, a police sergeant in St. Louis, Missouri, was working at a very interesting position dealing with, she worked in plainclothes and worked in the intelligence division. So she got to work very closely with the FBI. She was certified by the FBI to work with FBI agents. She had a take-home car. She investigated human trafficking and oversaw the gang unit. I mean, a pretty responsible position. But she got a new captain. And the captain decided that he needed to replace her with a man who seemed a better fit. Does that sound familiar? So she kept her rank, but she went to doing administrative duties. Her schedule became irregular. She lost her FBI status, and she had a take-home car, and she lost that too. She sued the city, and she alleged discrimination based on gender. And the district court said, sorry, you didn't lose your position. You may have lost some of your responsibilities, but you didn't lose your position, so no discrimination. So she appealed. Her name was Muldrow, Sergeant Jatanya Muldrow. And she argued that she was transferred because she was a woman and the transfer was a violation of Title VII of the Civil Rights Act. And the same thing happened in the Eighth Circuit Court of Appeals. They said, hey, no harm, no foul. You didn't lose your rank. So Sergeant Muldrow appealed to the U.S. Supreme Court, and guess what? The court majority set out a new standard. They said that Title VII does not require a plaintiff to show that alleged discriminatory acts resulted in harm that's significant. Remember, what the lower court said was insignificant harm. Same rank, no biggie. No harm, no foul. And it said the act doesn't say anything about characterizing anything as significant, serious, or substantial, or any similar adjective. Court said that they're no longer required to show significant harm. They must show that they suffered some harm. So how much harm is some harm? We don't know yet. Again, this is a 2024 case, and there haven't been any new cases. So do you think, based on what the Supreme Court said and based on the facts of the case, did Sergeant Muldrow suffer some harm? What do you think? I think she did. And as far as harassment cases go, in my experience as a fire chief, if I thought that an harassment complaint issue was serious enough, I use that old Marine Corps motto, kill them all and let God sort out. And if I felt like somebody needed to move, I would move both the firefighter alleging harassment and the alleged harasser. And then wait for the facts and figure out what steps to take next. And fortunately, that was not something I had to invoke very often because generally speaking, it didn't take much to convince the parties to accept a settlement of harassment and deal with it internally as a disciplinary issue. Now, we do have from EEOC some indication of what harm is. So, I'm sorry, this is a court case. This is November of last year. This is Thomas versus JBS Green Bay. It's not a fire department case. But now we've got a new standard, some harm. So the district court dismissed the suit on the grounds that there wasn't enough harm. None of the 7 grounds of the lawsuit involved adverse employment actions. But the Court of Appeals applied the Muldrow test and said, oh, yes, there were. And 3 of the 7 were discriminatory. They were discrimination. One was in her new position, there was a 3-year delay in training on a new machine. There was denial of vacation requests while coworkers' requests were okayed, and transfer to a different shift with knowledge of childcare issues. And the Seventh Circuit said that's enough. That was a discriminatory transfer. So that's the new standard, and fire chiefs and fire service leaders need to be aware of it, that the standard for discrimination in a transfer case is based on some harm, not on some significant harm. Now, we have another interesting case, and that involves a woman who was passed over for a position, and she argued that it was because she was a straight white woman and most of the rest of the people who worked around her were gay women, and that she was discriminated against because she was straight. The Court of Appeals said, well, you've got to come in with more than that because you're in the majority. So you need some kind of statistical evidence that you're not the only one this has happened to. And something other than just that you feel that you were discriminated against. And the Supreme Court heard oral arguments last month, and to say that they were underwhelmed by the lower court's argument was putting it mildly. And several justices commented that in the Civil Rights Act, there is no such thing as majority or minority. There was only protected class. So if this woman can substantiate her allegation that she was discriminated against, I think what the Supreme Court is going to say is she does not bring any more evidence in than that. That if she was discriminated against and she has the evidence to support that, that's all that the law requires. And there is no such thing as a majority or minority group. You don't see majority or minority mentioned anywhere in the Civil Rights Act of 1964.
I have a follow-up question for you on that. What would you tell somebody trying to report some sort of harassment as a female firefighter? I guess what words of advice would you give to them? Because I think a lot of people are hesitant for a bad outcome in the case, or that it's not going to be ruled in their favor, or it might not be worth it to make some sort of claim like that. What advice would you give them?
Well, it's tough for a claim like that in the fire service because A, the fire service has a long, long history of being primarily male in nature. Number two, it's very collegial and people have close relationships, and it's not hard to damage those relationships. Number three, my advice is if you think that you're dealing with an harassment case, I would go to the department. I determine if there's a legal aid organization in your jurisdiction that you should go to. These are things that really don't involve a lot of money output on the part of the person who is alleging the harassment. Notwithstanding that, if you have strong feelings that you've been harassed, then I think the thing to do is, again, look to legal aid and see if there's some opportunity for legal advice and perhaps some opportunity for an attorney to take on your case pro bono, which means doing it as a public service rather than expecting pay. I think a sophisticated fire chief will strongly encourage anybody that believes they've been sexually harassed to talk to that fire chief about it and let him know, because I think in some cases the fire chief can actually do something about it. And I've got several stories of experiences that I had after talking with the firefighter and sitting down with the firefighters on the engine company involved, that we were able to resolve it there and resolve it satisfactorily. And I think part of that was because I think all the firefighters involved saw that I took it very seriously. And I think the firefighter who was complaining of the harassment felt comfortable dealing with it in that kind of environment. But then I'm lucky. I've got the background of having a law degree, and I worked in legal aid after I graduated from law school. So not every fire chief has those characteristics or qualifications at his or her disposal. But be open about it. When it comes to sexual harassment training, this is one thing I can tell fire chiefs. Educate yourselves so when it comes time to do sexual harassment training in your fire department, do the training yourself so your firefighters know that you're taking it seriously as the fire chief. Do not do computer training. If you want to invite somebody over from HR to do it, make absolutely sure they know what they're talking about and they're credible. And you need to be there at every session, nodding your head and asking questions. So when firefighters see that the fire chief's committed to it. Oh, and the other thing is make sure that your company officers and chief officers are also involved. Some departments, mine included, did a separate training session from them so that they understood what their responsibilities were. Because sexual harassment is not fun to deal with. And the quickest way to really hurt your case is to pretend it doesn't exist and everybody will just forget about it. And most of the court cases I've heard involve chiefs who failed to act or chiefs that were disserved by other department leaders who decided that they didn't want to bring it forward. So if somebody comes to me and says, Chief, I've got to tell you something, but don't want you to do anything with it. And I say, if it's about sexual harassment, I'm sorry. But if it involves sexual harassment or a complaint of harassment, I will have to do something. But in the beginning of the process, I can do it quietly because that's the best way to start, and do it directly with the parties involved.
Okay. So we kind of talked about this a little bit earlier, but has the Pregnant Workers Fairness Act been a target of any executive orders?
Not yet.
Do you anticipate that it may be, or?
I think when EEOC gets a full house as far as the commission is concerned, it doesn't have enough for the quorum required to change a rule or a pronouncement. The Pregnant Workers Fairness Act itself is a law. The president has absolutely no authority to modify that law, although he's tried with several other laws, so there's no telling at this point. But the rules that were adopted by EEOC to support enforcement of the Pregnant Workers Fairness Act can be amended. And if there is a majority of the EEOC that is in favor of amending it, then what fire chiefs and fire officers and firefighters need to watch for is what those amendments are. And right now, I just know that the woman that's been nominated as chair of EEOC has some very strong opinions about the Pregnant Workers Fairness Act and about EEOC in general. So I'm anticipating some fireworks, if you will, coming from that appointment process when it's through. There are also some arguments over people being unappointed because of the way the EEOC is created. The same thing is happening now with the National Labor Relations Board, although that really doesn't apply directly to us because the National Labor Relations Act doesn't cover local government employees.
Has the EEOC been tracking Pregnancy Workers Fairness Act complaints?
Yeah, it's really helpful, and it kind of shows where we're kind of stumbling our way into the future. But there are 5 complaints that EEOC says they're popping up pretty regularly. One is unnecessary delays. In other words, a firefighter says, I'm pregnant, chief, and we need to talk about a reasonable accommodation. And then the line goes dead. No response from the fire chief. Unnecessary delays. The law requires an interactive dialogue between the fire chief and the pregnant firefighter, and it just doesn't happen. And that's a little bit like sexual harassment. And that is, there may be some fire chiefs that feel that they're going to be very uncomfortable with that conversation. And then they need to call for some mutual aid within their own department. Lisa Arnoff and I developed this idea that you apply pre-planning, the concept used in pre-planning, to pre-planning a firefighter pregnancy. And part of that is getting a number of people in the department involved so you have folks that can back you up and work with you in supporting a woman who's pregnant. Then there are fire chiefs who are asking for highly detailed medical examinations, and kind of the same thing that is required for the Americans with Disabilities Act, and that is not required by the Pregnant Workers Fairness Act. If the firefighter tells you they're pregnant, that's sufficient notice for you as chief to start assuming your responsibilities under the Pregnant Workers Fairness Act. The third one is firefighters who present an accommodation request, reasonable accommodation request, and the chief says, no, that'd be bad for department morale. Not a good answer. That would be an undue hardship. Chief, you've got to explain what the undue hardship is, and we'll talk more about undue hardship in a minute. That's a pretty serious change that's occurred in the law recently. Claims with no explanation or justification. We've never done that here. And violates our policies. The one I'm interested in the most is the excuse me, the personnel policy that some cities have that says that you use sick leave, or you can't use, you can't ask for an accommodation in light duty for a condition that is not related to a work-related injury. I think that won't work anymore. And my advice to cities and to unions who have that in a collective bargaining agreement is take advantage of the opportunity to do something different with that, because I don't think that's going to withstand legal scrutiny. The way the Pregnant Workers Fairness Act works is if it's good for one person in the fire department, it's good for everybody. And my advice also would be to look to other fire departments in your area that you work with and see what kind of accommodations they've allowed for, because the fire service grapevine is really incredible. And if one department is doing it, then the odds are pretty good that it's something that will turn out to be a reasonable accommodation and not an undue hardship for your department. And on EEOC lawsuits against employers, since we're running on a clock here, let me just say that the lawsuits so far have been a result of spectacularly stupid employer behavior, and I don't think fire chiefs are that ill-informed that they'll engage in it. But it really has to do with, for example, a woman who was pregnant. She said, I've got a new job. You've got training for me in the new job. I need to take a day or two off of that training to spend some time with my OBGYN doc. And the employer promptly rescinded the offer of the new job, and the person lost that promotional position. And the problem is there were other people in the class who took time off, and the employer let them take time off for the same thing with no penalty. So guess what? That employer lost. And we have a lot of cases like that. The pregnant worker who left, and when she wanted to come back to work, the employer said, we don't have any work for you, so we're not going to take you back, while continuing to go on and hire other new employees. Now, I can't think of a better definition of stupid than that, and I'd like to think the fire service community is much smarter than that. But it's a sign that EEOC is on the lookout for lawsuit opportunities. There is one case involved. This was one where where a foreman just said something stupid. There were 3 women in one of his departments. 2 of them were pregnant, and the other one was told him that she was considering in vitro fertilization. And he told her, presumably as a joke, you've got 2 folks who work with you who are pregnant. That's the quota. You can't do it. And EEOC said, bad joke. Don't do that again. That's a violation of the Pregnant Workers Fairness Act. So
we're
as long as you haven't taken a stupidity pill, just stick to the facts.
So we're about out of time, but I just want to ask, can a fire chief dictate a reasonable accommodation? Can like the chief just say what a reasonable accommodation is going to be?
No, you negotiate a reasonable accommodation. A fire chief doesn't necessarily have to accept an employee's proposal for a reasonable accommodation. That fire chief can say, here are the questions I have about it. Here's why I don't think it would work. Can you think of other things? But reasonable accommodation is what it means. Let's talk for a minute about undue hardship. The fire chief's defense under law to turn down a reasonable accommodation is that it would cause an undue hardship. This is really important. Back in the day, the undue hardship was what hardship would it work on your department? If you had to hire some more people on an overtime basis to cover a position, chiefs could argue before last year that was an undue hardship because their department had to hire more overtime people. But what the Supreme Court said in a case involving a U.S. Postal Service worker is that's not the way it works. You look at the capacity of the whole organization. So if your fire department is part of a municipality, it's an undue hardship as far as the whole municipality is concerned, not just the fire department. So that means that it becomes a local government burden. Now, if you're in a fire department that's a special fire district, then undue hardship is confined to your fire district. But if you've got a public works department and a parks and rec department and all those other departments, all of that has to be taken into account. That opens up an opportunity for fire chiefs and for those other department heads. And that is maybe you've got a firefighter that's looking for a reasonable accommodation, and there might be an assignment available, a light duty assignment available, if not in the fire department, perhaps in public works or in parks and rec. the one thing I'd recommend very strongly in your own department is please don't let a light duty assignment be a surprise to the customary recipients, the training officer and the fire prevention chief. They should be part of your pre-planning team so that you can say, think in advance about what you could use a person like that for in your department. Because as a former training chief, I used to hate it when somebody would come in and say, hey, you've got to find something to do for this person because they're going to be working with you for a while. And I say, hot damn. So undue hardship now, and I'm going to bet every dollar in my pocket at the moment that your mayor and your city manager are not aware of this because I try to keep up with what ICMA is doing, and I haven't seen a word about this in any ICMA online publications. So you might be the one to alert your human resources director and your city manager that the DeGroff case last year involving the U.S. Postal Service has completely changed the definition of undue hardship.
So unfortunately, we are out of time. And as you could tell, John is a wealth of information on things that are occurring right now within the fire service and possibility that things that will possibly come up. I want to thank Kat for co-hosting the show. Appreciate
Yeah,
that.
thanks, Kat. And
Um,
thank you, Lisa. It's great to work with you.
And I want to thank Fire Engineering again. Thanks to all the listeners and members of Women in Fire. Remember to follow us on Facebook, Instagram, and check out our website on womeninfire.org. And John mentioned that he had a PowerPoint that he presented at FDIC and at the Women in Fire Leadership Conference that he'll be forwarding to me. So if you would like to receive a copy of that PowerPoint, you can email me at lbaker@womeninfire.org. Again, thank you.